would have indicated that we would give space for that. Just before we get onto our witness today, that will start. With that, I would have indicated in that correspondence, which I repeat now, that we will allow the legal team of the public protector to take an hour to speak to that submission, which is a written submission sent to all members, and to give them an opportunity to clarify salient points of that submission. Probably thereafter, if there are any clarities, members would seek those, and would have the committee converging for a few minutes to discuss that, and thereafter make whatever ruling or decision, depending, and either way. And so this is where we are now, and I'm now going to, with that, going to recognize the public protector and led by her legal team, Advocate Mpofu, to start. Thank you. Advocate Mpofu, I now hand over to you.
Thank you, Chairperson. Good morning. Good morning, honorable members, evidence leaders, and everybody involved. Chair, let me start by indicating that the application is probably going to take more than the hour. We indicated that to you because that time frame was determined even before we lodged the application. So we're hoping that maybe once you've seen the application, you might consider our indication. But anyway, we'll cross that bridge when we get to it. Before we get into that, Chair,
you can just pause there before you proceed. You are given an hour to make the presentation, and I would want to respect that time that you're given.
Yes.
I don't want to take fear from your minutes, but just to clarify that we do have a standard in Parliament and the public protector will be the best person to know that anytime she comes in front of the Committee of Parliament, whether it's an annual report, which will run into 200 pages, there's a standard time given for presentation on the basis that somebody would have sent a written submission well ahead. We never go beyond 45 minutes of that presentation. It's a standard across that we do, but I would have added 15 minutes in addition to that. So I'm indicating that the hour is given to you for the presentation.
Yeah. Okay, Chairperson, I don't want to start on a wrong footing with you, but what you've just said doesn't make any sense whatsoever. This is not the first time we're doing an application here. And you've never given us 45 minutes before, so we can't start now. We've done applications before. I think the first one we were given 2 hours, the other one we were given slightly more. But also, if you say you have standards, one of the standards that govern your conduct here is called fairness. And an important part of fairness is consistency. So that's the standard that we are invoking. I'm saying to you that you, at the minimum, you must be consistent. You will remember that when we did the recusal application, you wrote us a letter and you said the application must be on such and such a day, rather the written application must be submitted on such and such a day, and thereafter, once you have looked at the application, you will then determine the duration of the presentation. And you did that, and it was the correct thing to do, Chairperson. But this time around, you changed your own rules, and that's the epitome of inconsistency, in that you gave us a time before you received the application. And we even discussed that at the meeting we had with the evidence leaders. To say, this is now strange, because how do you know the application might be 2 pages or 2,000 pages, or raise 2 issues or 2,000 issues? You're not a clairvoyant. You can't see, you can't determine a time before you even know what. I've never heard of that before. In any process, the decision maker will get the papers and then say, okay, this will take this long, this will take that long. And you fail to do that. So one of the things we're going to raise here in terms of inconsistency is exactly the fact that it looks like now that it's our turn to get into the leading of evidence, the rules are being changed. And that is wrong. It's just wrong. You can, of course, you can insist on unreasonably so, on sticking to your time frame. There's nothing we can do. But our duty is to show you that it's unreasonable and unfair and inconsistent and illogical. So that's the point I was making. So there's no point in telling me that that's all I have. I heard you the first time. I was just telling you that it's unreasonable. Anyway, before we do that, I was saying that there are issues that I wanted to raise before we deal with the application. And one of them is about, the first one, I think maybe you made a mistake or you forgot or whatever, or you were not informed, that we are not sitting on Friday because of an engagement that we've already discussed. But I think you said we're sitting the whole week, but I think that was a slip of the tongue. Yeah.
That's correct. Thank you for the correction.
Okay, thank you, Chair. Right. The second issue, Chair, is we have, you also made a remark about the witness. We have a serious problem, and we firstly need to inform you, but also hopefully get your intervention on it. Again, it goes to this issue of consistency. We have the feeling that now that the evidence leaders have finished their witnesses, the attitude regarding the witnesses of the public protector has suddenly changed. And it goes to the issues that were raised here from day one about the handicaps that go with the fact that the public protector is attending this process under the spell of an illegal, improper, and probably criminal suspension. And therefore that, contrary to what some people here were saying, this is unrelated. It's very related. because it affects how she's able to defend herself in this process. You'll remember, Chair, that we had an issue about emails and all that at the beginning, which was thankfully sorted out at a later stage, or access to her emails. Now we're facing different problems in relation to witnesses. As we speak, Chairperson, we've been interacting with you and the Office of the Public Protector for the whole of last week to ensure that the witness will attend today, excuse me, and at least on our communication with you, be in a position to give evidence at the latest by tomorrow, for the reasons that we have put in the correspondence. To say that that effort has been frustrated would be an understatement. Firstly, we raised it in the backroom meeting with the evidence leaders. Then we were told that no, it would be the Office of the Public Protector that is to ensure that the witness is here, or the witnesses for that matter, based on the normal rules that the entity that comes here normally foots the bill, which I know even from my own experience. When we tried to get that, the Office of the Public Protector, to cut a long story short, by I think Thursday, informed us that they were not going to assist. We came back to the secretariat of this committee, and we, after some other run around, we were told, I think by Friday late, that they would assist, or at least attempt to make an intervention, presumably with you or whoever makes those decisions. That has not happened. Yesterday, when we landed here, the first thing we did was to communicate with Temgosi to find out what is happening. And only then, I think it was 7:30 p.m., only then we got a message that said, I forgot the message. Okay, I'll paraphrase it. It simply said that the, sorry, let me just try and find the chair. Thanks. Dear Nafisa, that's one of our attorneys, please advise Mr. So-and-so, the witness, to remain prepared to travel to Cape Town in the morning, meaning today. I only received confirmation late on Friday and could not get assistance of a travel agent over the weekend. We will attend to it first thing in the morning. Regards, from Tembinkosi. This is almost 8 p.m. last night. I just spoke to the witness before coming here at about 8:30, and he hasn't heard from Tembinkosi or anybody. And he's just sitting in limbo, not knowing what to do. And these are people who are trying to assist this committee. You know, they're not sitting there with nothing to do. So that's where we are with that matter. And it's really regrettable, I think, to put it mildly. And if that is the attitude that's going to prevail, in order to frustrate the public protector from presenting her case, then we're going to have a serious problem going forward. We have observed before witnesses were brought here, and they were accommodated and kept in hotels, and travel arrangements made for them to come back, no problems. And now suddenly there's an inexplicable hitch. Yeah, so that's the problem that we face, Chairperson. So the truth then is that as we sit here, I don't know, Temgos is not here. I was told that he's available on the virtual platform. We literally don't know. Maybe he knows or you know what's going on with that issue. So that's the first thing about witnesses, Chairperson. The second thing is that we have, as you know from the list, we have made a request from the witness list to be assisted with some of the witnesses who might not be willing voluntarily to testify. Again, we've seen that happening before without any problems. In fact, probably without even any application, at least not that we have seen. But our first experience with the committee was its refusal to call an obviously relevant witness who has made remarks about the public protector which are relevant to the motion. But that matter is in court, thankfully, so it will be dealt with there. At a particular level, not directly. We have, as we indicated in the list we gave you, sent letters of voluntary participation to the following witnesses: Mr. Pravin Gordhan, Advocate Thuli Madonsela, and Ms. Natasha Mazzoni, all of whom, especially the last one, crucial witnesses, particularly to situate the entire charge sheet, so to speak, and some of the controversial issues raised therein, so that we know exactly what we're here for. Hold on. Okay, thank you. I was just double checking. The one witness, Mr. Gordhan, has sent us an attorney's letter, which I think we sent it to you, Chair, in one of the correspondences. But the long and short of it is that he's going to indicate probably this week what his attitude is. And the others have not even bothered to respond. The deadline, I think, was the 21st, which is last Monday. So we assume that they don't want to cooperate. In which case, if so that would then be 3 witnesses plus the one, Mr. Ramaphosa, that I referred to earlier, in which case, in respect of whom we had asked the committee to reconsider its decision, to try and avoid unnecessary litigation. We have also sent a letter to the acting public protector, Ms. Kaleka, who was identified, in fact, as long ago as the first day or second day of this committee. One of the members had actually indicated that people like her should be here. I think it was Honorable Hendricks, so that one can understand the chain of command and where the responsibility lies in respect of some of the issues that have been raised here. She also has a written indicating her let's call it unwillingness. So those are 5 witnesses in respect of which we would need the assistance of the committee. In your letter, Chair, which you wrote to us, you had said that those processes must be done by the 6th of December. Which made sense in the sense that presumably the reason why you put that date was so that the December and January break would be used to facilitate the subpoenas without wasting much time. So that's the update we wanted to give. All right. Then lastly, Chairperson.
Try again. I don't know what's happening.
Yes, no, I'm sure we've never had this this before. Okay, if it's maybe the IT people can tell us if it's just a temporary problem. It's just disturbing me. Okay, let me try. Oh. Okay. Thanks.
It's what?
Oh yes, I was saying, Chair, that your direction, one of your directions was that the process of requesting subpoenas, presumably once we have received responses from witnesses, obviously, would according to you, should be processed by the 6th, which is next Tuesday. And so I was giving you that heads up that we'll make that request in the next few days in line with that. Then there's another set, the last group of witnesses from which we needed your assistance. And that's also features in the review application, by the way, although in a different context of the recusal application. But it is the witnesses who did not finish their evidence. And that's Van Lochenberg, Pillay, and Baloyi. The last two were clearly did not even finish the cross-examination, but the members' questions were interposed. So that's a different set of witnesses where we're going to need your assistance. Hopefully, when we're raising this now up front, Chair, for a specific reason, so that we don't have to waste time on this when we resume. Hopefully all this will be resolved in between now and the break and the resumption. Now, coming back to the issue of the application.
Just as you get into the
Yes,
application,
okay,
just to indicate from the chair, we welcome the matters you have placed on record, and they will be responded to. But for now, I'm going to ask you to proceed on to the application.
Yes, well, that's what I was doing, Chair. And I was saying...
I wanted to make sure that we do...
Okay, you respond.
Yes.
Fair enough. Thanks, Chair. Yeah. So then, coming back...
Just before you proceed, pause, Honorable Melder.
Yes, thank you, Chairperson. I'm just unsure about the time. I heard you say you give Mr. Mpofu an hour, 60 minutes, but Mr. Mpofu referred to 45 minutes. So I'm not sure there's a misunderstanding. I just think we should have clarity in terms of what we're talking about exactly, please.
No, it's fine. Thank you, Honorable Melder. No, I'm clear about the time, so I would have mentioned 45 minutes and added 15 minutes. So thank you for that. I'll give you that minute back. Proceed. I'll forget
no, Chair, sorry, I've not started, but I'm saying that thanks for that clarification. The 45 minutes actually came from you and not from me. Yeah. But the point is the relationship between that issue of the 1 hour or 45 minutes or whatever it is, and what I've just said is twofold. One is the fact that I've explained to you that it's arbitrary and unfair and unreasonable. Whatever the 45-minute rule may or may not be, which we're hearing about for the first time here. But secondly, and more importantly, insofar as that 1 hour was meant to facilitate because you linked it to the issue of the witness. I'm putting my code. Sorry, I'm putting my code in somebody else's phone. You linked it to the issue of calling the witness. So I was showing you that it's also unreasonable in that sense, because there's no point in you rushing us to do an application in 1 hour, because there's no witness for the reasons that I've just explained. And so you can rush. If you rush us, you're rushing us just for the sake of rushing us.
Advocate Mpofu, I've given you an hour for the presentation of the application. I'm not going to entertain other issues that you're raising.
What does that mean, Chair? When you say you're not going to entertain, you mean I'm just speaking for the sake of
I've
speaking?
given you an hour to make the
So
application.
I'm not allowed to motivate.
You can raise that, but I'm saying I've given you an hour, and
Chairperson, I was here, I know that.
That stands.
Yeah.
Thank you.
No, don't thank me yet. I'm saying
Stands.
that.
Please proceed.
No, you have to listen. You have a duty at least to listen, Chairperson. You might disagree, but you can't refuse to listen.
Been
Okay?
listening. I'm asking you to
Yeah.
proceed.
Please listen. Okay. We have. Sorry. Sorry, just bear with me. Yes. Okay. Oh, no. Yes, we just received a message from the witness who says, "Good morning, advocate. Just got a call advising a flight at 2 p.m. and pick up at 12 p.m. So hopefully that's from that was from Temingosi. And that just emphasizes the point I was making, which means not only are we prejudiced in not being able to have the witness here because we wanted him to be here so that we could prepare him, but now he'll be whenever, 4 o'clock or 5 p.m. If we're lucky, if he does get picked up here. And yeah, so that's a matter. It's a crucial matter, Chair. Even if you don't want to listen, I think it would serve you well to understand that that is the crisis or problem that we find ourselves in, and that has a bearing. It must have a bearing on what will happen before. But it looks like you are determined to, irrespective of whether it's raining or not raining, or to stick to your guns, unreasonably so. That's fine. So now, if we come to the application itself, Chairperson, I need to situate this properly so that when you have your deliberations, you understand where we're coming from. And I'll try and preempt, because I think by now one can expect some types of questions. So I'll try and preempt them so that we don't have to waste time on irrelevances about what the application is and what it is not about. But anyone who has read the application, firstly, in your letter you said it was an application for recusal, and we corrected you that the correct terminology would be is an application for removal and or the replacement of the evidence leaders. We say it's a very serious matter, Chairperson, not a disruption as you always refer to issues that are raised legitimately by the public protector. And it's important to place it in its proper perspective. At the risk of repeating ourselves, Chair, this committee is governed by several prescripts which are not optional. And those are the directives that you have adopted, the terms of reference that you have adopted, and more importantly, the Constitution of South Africa that you have adopted as well. Maybe not you directly, but and all of those relate to the most important standard. You've just mentioned standards. And the most important standard that binds you, it's not optional or a favor that you are doing to anybody is articulated in the rules 129 AD2, which says that the committee must, when the word must is used, it means it's an obligation. It's not a discretion, it's not a favor. The committee must ensure that the inquiry is conducted in a reasonable and procedurally fair manner within a reasonable time frame. So even time frames, as I've just indicated a few minutes ago, must be fixed reasonably, not just at the whim of, well, it's 1 hour or bust. It has to be reasonable. In other words, logical and linked to something. But more importantly, the process must be procedurally fair. And what that means, again, at the risk of repeating ourselves, what that means, you have to, if you can go to paragraph 13, we'll just come back later. Yeah. Procedural fairness is something that is known and defined. It means two things. Here, the other side, and the other one is nemo iudex in causa sua, which means the so-called rule against bias. And that's the one we are invoking today, the second one. The issue of fairness, Chair, again, just to emphasize that it's a right to which we're entitled and not something that we have to be constantly begging for, is also contained in Section 34 of the Constitution. That's where actually this whole thing comes from. And Section 34 of the Constitution is a short one, so I'll just read it out. Everyone has the right to have any dispute that can be resolved by application of law decided in a fair public hearing before a court or, where appropriate, another independent and impartial tribunal or forum. Now, we all know this is not a court, but it is another independent and supposed to be impartial tribunal or forum. So whenever there's an issue that can be determined by such a forum, the standard of fairness applies as a matter of constitutional imperative, not as an optional extra. And there was a debate not so recently, I'd say about 10 years ago, as to whether this applies to tribunals such as these, which are not in themselves adversarial per se. And I was involved in that case. It had to do with the Marikana Commission. It's a case called Makidiwana versus Legal Aid Board. It went from the High Court in Gauteng to Bloemfontein and eventually to the Constitutional Court. And in that case, it was decided, Chairperson, that Section 34 does indeed apply to these types of tribunals. We were asserting that as a matter of fact, and the other side, the state, were fighting tooth and nail to say it's only confined to courts or so-called quasi-judicial proceedings. So it's settled law now in South Africa that the standard of fairness and procedural fairness should apply here. And that should make sense. That's one of the reasons why the Parliament saw it fit to impose upon you Rule 129 AD2. So that should really not even be a matter for debate, by the way. But in our experience, it's important to lay that foundation. Now, What then has that got to do with the evidence leaders? And this is very important, Chair, hopefully again to cut out unnecessary debate. We are going to demonstrate to you that the evidence leaders, at least the conduct of the evidence leaders that has exhibited itself here, or that has been observed by others, including members of the public, is such that if they continue to play that role, then it will be impossible for the standard set out in Rule 129(8)(d) and Section 34 of the Constitution to have been met. Try and say that again. We're going to show not that we'll refer you to the complaints made of professional misconduct and what have you, but we don't want anyone to tell us that this is not the LPC or Bar Council or whatever. We know that. So when we refer to these matters, we're not referring for those matters for you to resolve one way or the other the veracity per se of those allegations. We only want you to deal with that which has happened in front of your own eyes, firstly, but secondly, the issue of the perceptions, firstly of the public protector and the perceptions of the public. And that's important, Chairperson, because that's how you test fairness. And unfortunately, again, this is a point which I think has been lost here before. Fairness is not tested in respect of the subjective conduct of the person who is complained against. It's tested against the objective apprehension of the victim, to put it colloquially. In other words, the question is a simple one. Would a reasonable person sitting in the position of the public protector, who has been subjected to what we're going to discuss now, reasonably feel that she's going to get fairness from a process that is that is led or administered by the person complained against? So it matters not in that context whether that person is the chairperson or a member or an evidence leader or whatever, or someone at the door who holds the public protector from entering the door. But the point is whether that conduct amounts or does not amount to a fair process, and whether it's reasonable and procedurally fair. So I think that's important to dispel any notion that we are raising, when we raise these issues, we are raising them for the merits of the complaints. Right. Now, and I want to then say it up front, Chairperson, that the backbone of this application is that not just a person in the position of the public protector herself is of the reasonable opinion and view and has reasonably apprehended that if the evidence leaders remain in place, it's impossible for her to receive the promised fairness that's promised in the rule and in the Constitution. And yours is also, as a committee now, to live up to the obligation and the injunction that the committee must ensure the inquiry is conducted in a reasonable and procedurally fair manner within a reasonable time frame. So the obligation lies not in some other people, but in the committee itself. It's the committee that must ensure. And we're saying one of the ways in which you must ensure that the inquiry is conducted in a reasonable and procedurally fair manner is by granting the application for the removal and or replacement of the evidence leaders. So that's the context in which this thing is brought here. Apart from the fact, of course, that in any event we have a duty to exhaust internal remedies and make sure that it is raised here so that the committee either discharges its legal obligation or fails to do so. But it must be given an opportunity to do one of those two, either to discharge its obligation or to fail to do so. The other issue, Chairperson, which I want to raise also, before I get into the specific examples of the conduct, is something that also has seemed to be lost here, which is the issue of public participation. The issue that I raised earlier about the shabby treatment which has been given to witnesses and by extension to the public protector in respect of her witnesses is a serious matter because it goes to the issue of public participation. These witnesses are not here for fun, just like all the other witnesses. They are here as members of the public in their own right to assist this process. It looks like this parliament is of the view that public participation just means placing some advert in a newspaper and ticking that box and then you are done with public participation. No, it's not like that. It's something that must be at every step of the way. There must be an effort, a deliberate effort to ensure that the public participates. This is not your process, it's a process of the public. This is not your parliament, it's a parliament of the public. And you are just given certain tasks, but actually it doesn't belong to you. And that alone, Chairperson, is, so you can't ignore, or you can, because I mean, it won't be the first time, but you should not ignore the views of the public, including the members of the public who came here in the form of Advocate Kakane and Advocate Ngalwana and all the other public bodies that have commented on this matter, including, but not limited to, the Johannesburg Society of Advocates, the Pan-African Bar Association of South Africa. Those are civil society organizations representing the public, and you will ignore them at your peril because the public is watching whether you really mean it when you say this process is characterized by public participation. And indeed, even the public protector, in her individual capacity as a member of the public, she herself expects this parliament to follow the Constitution. She herself expects this parliament to follow its own rules, its own terms of reference, its own directives. And she's entitled to demand that, by the way, not to ask for favors. And therefore, I've referred you to Section 34 of the Constitution. I'm now referring you to Section 59 of the same Constitution, which I've read to you before, but I will do it again. It says, the National Assembly must facilitate public involvement in the legislative and other processes of the Assembly and its committees, including this one, and conduct its business in an open manner and hold its sittings and those of its committees in public, but reasonable measures must be taken to regulate public access, including access of the media to the Assembly and its committees, and to provide for the searching of any person and so on. Paragraph 2 says, the National Assembly may not exclude the public, including the media, from a sitting of a committee unless it is reasonable and justifiable to do so, and in an open and democratic society. What that means in simple English is that every activity of this National Assembly and its committees must involve an element of public participation. And that's one of the issues we raise here when we refer to the public comments that have been made in respect of the issues that we raise. So if you can then please go to page 5. Right. So we then now go to the heart of the application, Chair, which is the conduct that is complained of. And we start with what we call the main ground, which, to use the terminology we've employed before in a different context, was the proverbial last straw, because there were other issues that we raised with you many times before. We are aware that there were issues that were raised by other political parties, and before, there was an application last month or a month before for the recusal of the evidence leaders brought by others. And we made it clear in our letter to you, because again, unfairly, you were saying to us, there was a recusal application, and you meaning the public protector, you did nothing. Or we said nothing. Well, we want to tell you, we did say nothing, and that was deliberate. We stayed away out of the fray of that particular application, which was brought by the UDM, I think primarily, and also the EFF. Because whatever gripes those parties may have had, in our estimation at the time, were issues that they were uncomfortable with, which they were entitled to raise as members of the committee. But there was no direct reference to the public protector. Obviously, there'll always be an indirect reference to her in anything that's happening in this committee. But we deliberately, I just want to put that on record, it was not a mistake. Deliberately stayed out of that entire, you would have noticed that, in fact, by the way, you never even invited us to comment, which is another story. We were watching it like other people, and the evidence leaders were given an opportunity to comment on it, and we were not given an opportunity to comment. Which, Chairperson, that brings me to another issue which I would like to raise with you. Maybe you can respond for the benefit of those who are watching, or those who may not be aware of the interactions we have had. When you wrote to us on Monday last week, I think it was the 21st, in response to our notification of this application, you gave us well, in typical fashion, an extremely unreasonable deadline of having to file the written application by 5 o'clock on the 23rd of November. Well knowing that we were preparing to go to the Constitutional Court on the 24th, which we have reported here. but you gave us that time frame of less than 48 hours, so to speak. And because we did not want to be set up for saying that we did not meet your deadlines, however unreasonable we might think they are, we met that deadline. And we sent you the application at that time, or before that hour. One of the reasons you had given us for giving that deadline was that it would then enable the evidence leaders to respond by Saturday, the 26th, so that if fairness were to be observed, we also have the benefit of their response and prepare accordingly. As I speak to you, we have not received that response, which was promised to us for the 26th. So I don't think you give them deadlines, but if you gave them any indication that they should do so, it means that that deadline has not been met, or it has not been sent to us. I don't want to accuse anyone. Maybe they met the deadline, but it was not sent to us, which would also be meaningless. And yet you impose deadlines on us in the manner that you just did this morning. No explanation. You don't say to us, the committee was supposed to give you a response on Saturday. You don't have it for this and that reason, and therefore whatever. No. We are just, not human enough to deserve even those kinds of explanations. So we do this application as you force us to do now, without even the benefit of that. And when it is given to us, I'm quite sure either you'll give us 2 minutes to read it, or you'll tell us whatever you want to tell us. But that is the kind of treatment that we have come to expect in these quarters. Anyway, coming back to the conduct, Chairperson, that we are complaining about. We say at paragraph 21, and I'll try and read out some of these just to save time. On 2 November, during the evidence of Mr. Niels van der Merwe's testimony, the evidence leaders caused the names and fees of various black counsel and attorneys who do work for the Office of the Public Protector to be displayed during the inquiry, while knowing very well that the proceedings are aired on YouTube. You can add to that television, sometimes on live television, certainly on channel 408, which is totally all watched by millions of people. The evidence leaders failed to give any prior warning to the advocates and the attorneys concerned. They also failed to give context to the figures in terms of the period over which the fees were earned. It's 5, not 6 things. There's a repetition there. Period for which the fees were earned, the number of matters that each advocate was briefed on, the volume of work to be done, complexity of the matter, and the applicable tax deductions and other associated expenses. And we say furthermore, the witness through whom the evidence was led, testified that he only assumed the position of senior manager of legal services on the 1st of August. He testified that Mr. Thembigosi Muntu is the person who had been in charge of the legal department. Despite the fact that Mr. Stole was one of the witnesses who gave testimony, evidence leaders decided to lead the evidence in question from someone who clearly did not have personal knowledge of such evidence. this was bound to be problematic. There is no suggestion that Mr. Stolle was unwilling or unavailable to deal with the evidence. After all, it was during Mr. Stolle's evidence that Mr. Kevin Mileham made the initial statement which led to the leading of the said evidence. That's the famous list of those who benefited, quote unquote. And we say that the evidence leaders are themselves advocates, and they knew that their conduct was prejudicial to the privacy and dignity of their colleagues and prejudicial to the legal profession at large. They knew that their conduct would cause professional harm to the advocates and attorneys in question. Furthermore, evidence leaders knew very well that flighting such global amounts without proper context would be misleading to the committee, the public, and to anyone who watched the proceedings, and paint the incorrect picture which was originally sought by Mr. Mileham, who had referred to the practitioners who had, quote, benefited, unquote, from the legal fees paid by the Office of the Public Protector. In other words, the evidence leaders then advanced the cause of Mr. Mileham wittingly or unwittingly, whatever he wanted to communicate by that terminology. In some instances, the amounts flighted were not correct because the evidence leaders did not take time, at least to consult the advocates and attorneys concerned. Let me just pause there, Chairperson. This is a very serious matter. We know that it's now common cause that the figures were inaccurate in many instances. That has been admitted by the evidence leaders. It's also relevant to the so-called apology which was given by the evidence leaders. Because their apology, which you'll remember was not accepted by the people to whom it was directed, because they did not think that it was genuine. But the following day, it was made on the 10th, and on the 11th it was qualified and restricted. The evidence leaders said, no, they did not apologize. They only apologized about the inaccuracies. In other words, they didn't apologize for the head and all the things that were said here. And that alone is, should be worrying to a reasonable committee. Well, but the crucial thing about that, Chairperson, is that those inaccuracies to an inquiring mind should go a long way, because they say two things. One, what other inaccuracies have been bandied about here, where there were no people who were protesting about them for them to be corrected? That's the first thing. But the second and most important thing is that, and you don't have to take my word for this, but because I did read out extracts that shows the duties of advocates, at least to each other. This is the issue that was raised sharply by the persons who addressed you here. That the evidence leaders, as practicing advocates, because that's why they were chosen. Otherwise, you could have done this yourself as a committee and lead the evidence yourselves. But the reason you wanted to have advocates is because you wanted people who readily and automatically understand the roles and the distance and the arm's length and all that, because that's their training. It was not because Parliament just wanted to waste money and pay advocates. It wanted to get that particular professional distance, if you like. Otherwise, we could have just chosen one of the members to be the evidence leader. Now, we have demonstrated to you that one of the duties of advocates is to be collegial. And that simply means that the evidence leaders should have called their colleagues and say, colleague, we have a client here called the committee. You know the rules. We don't call the shots. It's the client. The client, if the client asks you for an unreasonable thing, it's the fault of the client, so to speak. And anyone who has ever practiced law will know that that happens. But that can never remove the duty of me as a practitioner to say to the colleague, look, tomorrow I'm going to be in court. There's some witness who says they saw you in some place where you should not have been, and I'm going to have to put that to the witness. It happens all the time. Why is that important for your purpose, Chairperson? It's important because had that happened, the inaccuracies would have been corrected. You can be sure of that. That if the evidence leaders that called Advocate Kakane or Advocate Ngalwana and said, I'm going to do this, they would have had some kind of discussion, but in the end they might have said, oh well, you have to do what you have to do. But let me just tell you, those figures are wrong in this way and that way and that way, and that would have been disposed of at that level. So it is the failure. It's not that this thing about the correctness of the figures is exaggerated. It's a complete irrelevancy from any other point of view, because it doesn't matter what the figure is. The imputation of looting remains the same, number one. But number two, this issue that I'm raising, the failure to communicate with the persons, also remains the same. So that's a major transgression which is done in your name as the committee. And we say at 26, had they done so, it is reasonable to assume that such inaccuracies would have been avoided. The evidence leaders' conduct sparked confusion and mayhem in the country and in the legal fraternity. A screenshot containing the fees and names of concerned advocates and attorneys predictably went viral on social media to the detriment of the family members of the concerned attorneys and advocates. The persons involved were also exposed to criminality and other forms of harassment and insults. Now, again, this might be a laughing matter for those who are not exposed to these things. But anyone who lives in this country knows that if you portray somebody as having some largesse, whether that person is an advocate or an attorney or a farmer, or we hear all sorts of things about how farmers are exposed to criminality because of the belief that they are sitting there with some deserved or undeserved loot. But these are realities of our society, and those who are concerned about things like that should not only be concerned when they affect white farmers, but the exposure of anybody to those kinds of dangers should be of concern to any self-respecting South African. And this is what happened, Chairperson. Put aside the fact that all this, by the way, was completely irrelevant. Completely irrelevant, or at least we'll know when Ms. Mazona comes here, what she meant, whether in any event she wanted to deal with anything to do with legal fees, or whether, as it says in her affidavit, or rather in her charge sheet, she was dealing with legal costs. So all this could be really for absolutely no value whatsoever to this committee, because it deals with a topic in any event that is not in the charges. But that's a matter for another day. We're saying at 29, the evidence leaders failed to recognize or acknowledge once it was pointed out that the evidence was irrelevant in that it deals with legal fees, while the motion of Ms. Mazoni refers to legal costs, which is a different thing, as correctly considered by Mr. van der Merwe. We say they failed to recognize or acknowledge that the evidence was irrelevant, that had nothing to do with so-called wasteful and unauthorized expenditure, which is the sting of that charge. That's why advocates were accused of looting. And or to inform the members that even if the display of the evidence was necessary, which is denied, there was absolutely no reason to include the names of the practitioners. We've already gone through this, and Mr. Skakane, Advocate Skakane and others also explained it, that this was not an attempt to hide the evidence or to make sure that it's not, if the committee thought it was relevant, rightly or wrongly, it could have been done without attaching the names of the innocent people. And again, the witness, Mr. van der Merwe, considered here that there was nothing untoward in respect of each of the persons whose names were brandished here. And we say they also failed to apologize even when the hardship associated with their conduct was explained. They elected to limit their apology to the issue of inaccuracies. I've already addressed that. It's a very serious matter. Now, one of the most important things, Chair, is what we said at 29.5, because that involves both you and the evidence leaders at the same time. It was, for me, at least the most remarkable thing to witness, I must say that. Because you, Chairperson, said to the advocates who addressed the committee here that you would receive their document and you would respond to them in due course. But the following day, you reversed that and you were hostile and shouting at us for no reason, when we were simply reminding you that you had made an undertaking to those advocates to consider their submissions. So you couldn't very well reasonably repeat exactly that which you had said. You say to people, okay, wait, we will consider your grievances. And then the following day you do exactly that which you said you are going to consider. What if when you consider it, you find that this was the most diabolical violation, but you've just repeated it willingly and unprovoked? And that goes to the evidence leaders themselves, because at least once they had listened to their colleagues and they are pleased, they should never have participated in the repetition of that conduct, even if, in this case, the client was insisting on it, because there's a limit to which you can exercise your own professional judgment. And I think that, for me, indicated, firstly, that such apology as there might have been was, as the other colleagues suspected, definitely not genuine, and certainly it was not backed up by the repetition. I mean, you know, even as parents, I'm sure that it would be clear, because if you said to your child or somebody else or anyone, whether they're not a child or not, that this should not happen, and then you say, okay, we'll consider that, and then the following day you do exactly that which is still under consideration. It then means you don't take the person seriously who has taken the trouble to lodge the grievance to you. And we say the chairperson acted outside the scope of his duties in shouting down objections by the public protector and unilaterally taking decision to allow the repetition of the exercise on the 11th, while he, the chairperson, had requested for written representations on the issue. And we raise that in context, but the focus of the application is on the role of the evidence leaders, which I've just explained now. Now, Chairperson, if you allow me to just refer you to some of the Can you please go to RA1? It's marked 465. I don't know what that means. Yeah. Okay. Yeah. This is the document which you had asked for, and which, as I say, you breached even before you had received it. And these are the words that were used by members of the public, and some of them were used here in this room, but certainly used out there about the conduct of the evidence leaders. And these are people who are clearly neutral about this, unlike the public protector who might be accused by you to be feeling this way because she's the affected party. In other words, you must understand that if other people out there could feel like this, then how much more for the public protector, who's the direct victim of this. If you go to paragraph 3, they say, and I quote, "But we are also here to alert you that people like Ms. Bauer, a supposed colleague, can abuse such an important process to prejudice their colleagues and to fight battles that have nothing to do with your constitutional mandate about which you are here concerned." And at paragraph 4, they say, "Ms. Bauer knowingly and purposely brandished our names without any context, read out alarming figures she submitted the money we have been, quote, given by the public protector. She knows that counsel in our referral profession submits their fee notes to the instructing attorneys for payment for legal services rendered." Number 6, Ms. Bauer intended theory to portray black professionals as corrupt simply because she does not like them. We reject as unprofessional her conduct to use her position in front of this august structure to further a stereotype that should be vanquished. We reject her cruelty or to condemn what us, particularly black juniors with whom we work, to be perceived as corrupt when we do our work, just as she and her white friends do in the profession. And then at paragraph 7, I'm just jumping for time, it says, "A person who regarded as a colleague did what she did last Wednesday, knowing full well that the public had indeed, some of you may not have been aware that some of her figures are wrong, that she omitted to impart the important context of the period over which the figures were accrued, even if they were accurate." Number 8, Ms. Bauer hung us out to dry in her attempt to perpetuate stereotypes that black professionals are looters and that their knowledge is of no value that should be paid for. So I venture would have been the legal fees paid, or a far more useful comparison for the purposes of this process, I venture, would have been the legal fees paid to each of the white advocates and white law firms that rendered legal services to Madonsela. And then number 10, it's predictably, this is important, predictably, because nobody who lives in this country really can say, oh, we were shocked that this thing was on social media and so on. We're not that naive. It says, predictably, she did find fertile ground in the Daily Maverick that now characterizes our fees not as having been earned for legal services rendered, but as monies having been, quote, funneled through Advocate Mkhwebane. Her theory seeks to use this important process to perpetuate an old racist stereotype that Africans are forever children who require policing by other races. Otherwise, they will be up to no good. Her theory is indeed dangerous and constitutes an antithesis of the democratic mandate of this parliament. And then I jump to 13. From our vantage point, it is hard not to conclude that this was what Ms. Bauer intended. And then quotes the newspaper articles that Bande at 14 spoke to these people as RAT tricksters and foes of the Constitution. At 19, it It says, yeah, if you care to check their fees, you would be surprised by the double standards of these people that have bestowed upon themselves the duty to police black people they regard as inferior, irrational, and childlike beings that require supervision of the superior races and those who have been elected to be an appendage to whiteness. And then at 22, it said, as for Mr. van der Merwe, and this is an issue we raised with you, Chairperson, his conduct is astounding. On 16 August, I, as Moses Kakan SC, consulted with him in respect of a huge matter I was doing in the office of the BP. I have since withdrawn from this matter, which is being heard as we speak in the Bisho High Court. Not once did he indicate to me that during his testimony he would be flighting my name and my supposed income in the full glare of the media and the public. He also consulted with Ngalwana SC and omitted to alert him, and so on. You'll remember this is a matter which I also brought to your attention, and there's a letter from the acting public protector which confirms that Advocate Kakana was forced to withdraw from the matter in terms of the rules which I quoted to you. Lastly, paragraph 23, they say, Chairperson, both Ngalana SC and I are here to set the record straight and to assure the public and yourselves as a representative of our citizens that despite Ms. Bauer's cruel and deliberate display of our names, we have done nothing wrong. She carefully selected those of us she seems to have, for some reason, sought to discredit. She must pursue her own stereotypes outside of this forum. Her conduct supports the justification of the structure of domination through racist myths, prejudicial innuendo against black colleagues. And there we pick out the question, the issue is she must pursue her own stereotypes outside of this forum. And that's, as it were, the gist of our application. Then, Chairperson, if those people, again, maybe like the public protector might be accused of having been, what do you call it, protesting too much because their own names were brandished. Well, then here's a RA2 is a letter from the Johannesburg Society of Advocates. Now, that's the largest bar in South Africa and certainly cannot be accused of having any particular interest or bias in this matter, or inherent bias or self-preservation or whatever else can be said about the other people. They say, can we go to the 4th paragraph? And this was a public statement which they made and released. Sorry, it's a bit fuzzy, but I'll read it out. They say, during the course of his testimony, Mr. van der Merwe testified in respect of a spreadsheet setting out the professional legal fees of certain advocates. These professional legal fees were said to have been incurred by the Office of the Public Protector between the financial year 2016 to 2022. JSA notes with the purported reason for the evidence having led being, quote, to provide the committee with an indication in broad terms to offer what the public protector was paying in relation to legal fees. There we go again, in other words, the irrelevancy, and which matters were regarded as priority on which limited funds were to be spent. Then, if you jump to the next paragraph, this is the important one. It concerns, yeah. It concerns okay, now let me read the other one. It says, in seeking to achieve this purported objective, evidence in respect of a selected few advocates was led. In doing so, the names and fees of the selected few advocates was disclosed. Singling out of these selected advocates concerns the JSA. And then here's the gist. It concerns the JSA because no worthy justification was provided for having singled out selected few advocates. Very important. No worthy justification. And that means they would listen to all the justifications that were made here, but none of them held any water. And it says the nature and extent of the professional services rendered by the selected few advocates was not disclosed, which we now all know, either, nor the time period within which those services were rendered. This is crucial. So it's one thing if you say somebody quote-unquote, benefited to the tune of 2 million rand. That's a big wow. But if you explain that that was over a period of 6 years, and they did 200 meters at 10 rand each, or whatever the correct difference is, I mean, the multiplication is. Then you clearly are misleading, deliberately so. Now, here's the important crux of what the JSA was saying, Chairperson. This seemingly malicious disclosure of evidence presented as it was is regrettable. Now, that's not something that advocates of this caliber and this such as big bar can make lightly. An allegation of malice. Malice is the worst form of cruelty that you can mete out against a fellow human being. And that was the view, that this was a malicious act. And then, if you jump 2 paragraphs, the JSA believes that it was inappropriate to disclose and discuss the names of fees of selected fee advocates in the manner the inquiry permitted. In other words, the committee permitted something that was inappropriate. Such conduct is highly prejudicial to legal professionals and to the repute of the profession. Another very serious statement. Bringing the profession into disrepute is not something that is must be made light of. So it was not just the advocates concerned, but the profession itself which was brought into disrepute. Such conduct is highly prejudicial, It also negatively affects the rights of advocates to practice their profession as guaranteed by Section 22 of the Constitution of the Republic of South Africa. So that's a third section. So as I've referred you to Section 34, Section 59, that's also Section 22. Then they make the obvious point that it's disconcerting, especially in public proceedings followed by the nation and beyond the South African borders and widely reported by the media. That's the point I made earlier. The gist, for your purposes, Chair, is the last paragraph. The singling out of these few selected advocates having executed their professional obligation is improper and unfair, right? Improper and unfair. And when you see unfair, your sensibilities of justice should be provoked, at least. I mean, you know. And they say the National Assembly should not tolerate such conduct in its proceedings. And that's really what we're talking about here. The National Assembly, here represented by you as a committee, should not tolerate such conduct. So if you tolerate it, that's fine, which we suspect you will. But the public feels that you should not tolerate such malicious conduct. And no amount of voting to say that the thing was not malicious and so on will change it from what it is or what it is perceived as. I've made that point before. If you vote or abuse majority numbers to vote that we are currently sitting in Spain, it doesn't mean that that is true. It just means it doesn't mean you are correct, it means you are many in your incorrectness. Then the next is a statement by Pabasa, again, a reputable structure of the profession, Pan-African Bar Association of South Africa, which is a newly formed progressive bar. So you've heard from what you might call the traditional bar. And this is what Pabasa says. Third paragraph. The first part of the spreadsheet in the screenshot does not indicate a time period during which those fees were paid, nor does it indicate what cases these amounts for, how many cases were involved, and so on. And then the last sentence, presenting the information in this way in public hearings, which are live screened, inevitably allows this information to be presented in the public domain out of context with all the damaging consequences that flow from this. Inevitably. The other one said predictably, so it's obvious. And then the next jump, the one that says second, the last sentence, say, in fact, so on social media, the screenshot was circulated with the title, quote, Mkhwebane and her friends were looting the office. All that was inevitable and predictable. Then the next paragraph is the jump, the first one, the one that starts with while we accept. It says, this has a direct and adverse impact on the public perception, which should concern you, of the professional integrity of the council listed on the spreadsheet and ignores the commercial reality that council provides service in return for a reasonable fee, which is reflective of their expertise, experience, knowledge, and skill. It plays into the unfounded narrative of Black Council, quote, fleecing the state, which is reflective of the stereotyping that we continue to see in the media and in the profession. This must stop now. How does it stop? By this committee taking action and not ignoring its obligation in section and rule 129 AD. The last one from Pabasa says, the section 194 proceedings are public and all evidence presented by evidence leaders is live streamed. It was thus inevitable that extracts from the evidence would be shared widely on social media. Greater care needed to be taken by the evidence leaders and the parliamentary committee to avoid the negative and unfair consequences of the screenshot. For example, it is not clear why the names of the advocates were paid, the amounts each were apparently paid and is relevant to Section 194 inquiry. This is crucial. So irrelevance in the secondary sense, even outside, even assuming the Mazone motion was what it was not. And it says, a simple global amount of council's fees for each matter could have achieved the same purpose without sensationalizing the names of particular council who were simply doing their job we are all paid to do for our clients. And that's signed by the chairperson and deputy chairperson of that body. Now, the last annexure, Chair, is the letter from the CEO of Public Protector South Africa to Advocate Skakane regarding his withdrawal from the matter of Oscar Mabuyane. And there basically some kind of mea culpa. They say, evidence presented at the Section 194 committee is not at the insistence or within the control of the PPSA leadership. In other words, it is at the insistence and the control of the evidence leaders. And then later, they say the members subsequently requested particular evidence. Okay, we've already gone through that. Paragraph 7, which is more important, because it goes to the conduct of the chairperson as well. While the PPSA fully appreciates the concerns as encapsulated in the letter, it is noted that the matter was raised directly with the committee on the 10th. The chairperson, Mr. Janchi, indicated that members of the committee will not engage on the concerns raised by you and Advocate Nkalwana on the said date and will await formal communication on this matter. And as I've indicated, while that was happening, you simply just repeated or allowed the conduct to be repeated. So that's the gist, chairperson, of the conduct, which clearly has caused a public outcry, rightly so, but is associated with things that this committee should not be associated with: racism, malice, improper conduct, unprofessional conduct, the perpetuating of stereotypes, the predictable prejudicing people's rights, breach of Section 22 of the Constitution, you name it. I'm sure this committee would not be proud to be associated with that, or at least to have seen to be turned a blind eye to that litany of complaints from members of the public. So that's, I mean, it would be, I don't even think even a child would understand that that kind of conduct goes to, can not just to bias as such, but goes to conduct which should not be associated with any democratic parliament anywhere in the world. But we then go to B2, Chairperson, which is the issue of the cross-examination of witnesses. Because this was, as I said, that was the last straw of the issue that I've just dealt with. But even before that, there had been conduct which should concern any right-thinking person. And the first one is that the evidence leaders violated the directive by cross-examining Mr. Tembinkosi Muntu-Sithole. A witness was called and prepared by the evidence leaders. I'm on 49, yeah. To the extent that the witness felt unprotected by the chairperson until he cautioned the chairperson to be more in control of how witnesses are questioned. This occurred despite an objection from the legal representatives of the public protector, who brought it to the attention of the chairperson that Advocate Bauer was in fact cross-examining the witness. Now, in fairness to Advocate Bauer, she never denied that she was cross-examining the witness. It was only the chair who tried to do that. But I think her assertion was that she was entitled to do so. Well, she was wrong about that. But at least the actual conduct, I don't think no one who's trained in law would mistake what cross-examination is, as symbolized by expressions like "I put it to you" and so on. Well, let me put it this way. It's not just a statement like "I put it to you" that indicates that this is cross-examination. But the most important thing is actually evidence leaders have nothing to put it to you. Evidence leaders are not prosecutors, and therefore they don't have a version to put to any witness. You know, the "I put it to you" statement is meant for a practitioner who puts a version of their own side to the witness, so that that witness must be seen to have been given a fair opportunity before that side, as it were, puts its case. It's very simple basics, Law 101. So the mere fact that an evidence leader puts it to you knows that, then it means we're already down the slippery slope. Now, Chairperson, as you know, I said to you, it's not just the Constitution and the directives. The terms of reference, any commission, by the way, this is a democratic republic. So nobody just does something out of the blue. You do things within the confines of that which has been circumscribed by whoever delegated the power to you. Your terms of reference say at paragraph 5 thereof, the inquiry is inquisitorial in nature, and the evidence leader does not act as a prosecutor. Now that's fundamental, Chairperson. It's so fundamental, I don't even know how to emphasize it to this committee. But let me try and break it down. Prosecutors, and I don't have time to give you the entire law of prosecutors, but prosecutors have a duty, even prosecutors, let me put it that way, have a duty to ensure that the tribunal is given fair information, that the fair trial rights of the person are preserved, and that they place in front of the criminal court even evidence that might be helpful to the accused. That's a prosecutor in the first day of training gets told that. That's what you do. If you are found to have not put any evidence simply because it's going to help the accused, then you are not discharging the duties of a public prosecutor, because you are now no longer representing the state, you are representing yourself. Now, if that is the case for even prosecutors, remember, evidence leaders are not prosecutors. Now, when they don't even meet the standard of a prosecutor, then what have we got left? And Chair, as I said, I don't have time to do all the cases, but I can just read out to you some of the extracts. There's a case called S versus Mulula. It says that the court insisted that the prosecutor's role was different from that of counsel or an attorney representing a client. Let me pause there. So the difference between the evidence leaders and us is that we are representing a client. They are not representing a client. So the standards by which they are supposed to operate are even different from us, let alone from prosecutors. And it says, the prosecutor stood in a special relationship to the court since their primary duty was not to procure a conviction at all costs, but to assist the court in ascertaining the truth. Another crucial difference. So even a prosecutor, their duty is not to secure a conviction, but the conduct of these evidence leaders has been that their duty is to secure a finding of guilt against the public protector. So they have not even met, even if they were being charged by the standard of prosecutors, they would have failed, let alone even the higher standard of evidence leaders. They say that such practice was said to the court to be wrong where prosecutors act contrary. Wrongly supposes an obligation on the part of the accused person to explain the motive of false accusations by their accusers. But in another case, Chairperson called Porritt and another versus National Director of Public Prosecutions, the following was said, that the standard used there is different from that which is used for judges and magistrates, which is obvious. And say, Chiqui J.A., writing for the unanimous full bench, noted that in our adversarial system, the role of the prosecutor makes it inevitable that he or she would be perceived as biased. And I'll say something about this. Let me say it now. What the Supreme Court of Appeal was explaining there was that although there are these standards and the prosecutor is not really representing the state or the people, as they say in America, the people versus so-and-so. It's inevitable because that system is adversarial. It's inevitable that the prosecutor is seen to be representing a particular side, yeah, even if that side is the people. But here, there's no such leeway when you're dealing with evidence leaders. They can't even be seen to be anywhere between being biased. It says, it was noted that prosecutors are required to present the case for the same state firmly, but fairly and dispassionately, even prosecutors. However, the fact that prosecutorial functions are carried out vigorously and zealously, that a prosecutor is partisan and might not hold a very strong view that the accused is guilty, cannot provide grounds for accusal. It follows that the SARFU test is not appropriate. That's what I was telling you about, the one of judges and magistrates. And says, however, recusal of a prosecutor on the grounds of bias or apprehension of bias arises where the bias of the prosecutor affects the accused's right to a fair trial. That's the gist. That's what the Supreme Court of Appeal said. In other words, all this may or may not be, they might be perceived or whatever, but the minute it affects the procedural fairness rights of the person, then the prosecutor must be removed. It says, Chiqui referred to a case in Zimbabwe of Smith with a Y, S-M-Y-T-H, versus Ushe Wokunze, where removal of the prosecutor was necessary because the accused's fair trial right was placed in jeopardy by the vindictive manner of the prosecutor and his dishonesty in deliberately misleading the court. So conduct unbecoming, as it were. And the judge said sufficient structural guarantees in South Africa to ensure that an accused's right to a fair trial is protected, irrespective of whether the prosecutor concerned is an employee of the NPA or an outside counsel funded by SARS or any other entity. So even if it's outside counsel, like in your case, the standards apply. So, Chair, this is the most crucial submission, which is that your terms of reference, your directives say that the evidence leaders, by the way, that states the obvious, should not act as prosecutors. In other words, you yourselves as Parliament have decided the standard. You say they must not act as prosecutors. But what we are busy showing you is that the standard of evidence leaders is even higher than that. But if they can't even jump this hurdle, which is lower, of prosecutors, then it's impossible that they could have jumped the higher hurdle of evidence leaders. I mean, that's just a matter of logic. If anyone who has ever watched high jump at school will understand it. If you can jump 1 meter, then you surely cannot jump 2 meters. It means, so if you fail to jump even the lower bar, then you, as a matter of logic, cannot have been seen to have jumped the higher bar. So that's what happened there, Chairperson, the issue of that cross-examination, which is not allowed by any standards. There's a reason, this is the reason, what I've just explained, Chair, why your directives say at 6.8. If you can please go to 51.1. Okay, let's just do 51, the whole 51. I'll read while you're putting it up. I say, Chairperson, the point I've just made, there is a very good reason why the applicable directive clearly differentiates, there should be an S there, between the right of the public protector to cross-examine and the right of the evidence leaders to, quote, put questions. So that terminology was deliberate in your directive, which you adopted here in July. It says we have a right, it makes the point I was making that we should even be charged by a different standard. We have a right to cross-examine and they have a right to put questions. The evidence leaders have no right to cross-examine simply because, unlike the public protector, they have no version to assert or test by way of cross-examination. Neither do they have a right to, quote, discredit any witness. That can only be done by a person or a party which has a version and a desired outcome which is in conflict with the evidence of that particular witness. That is the sole purpose of cross-examination. For that reason, it is clearly important to illustrate the point. So unless if you have an objective, an outcome that you want, you can't put a contrary, so-called contrary version to the one that you think is helpful to the other side. And we say clause 6.8 of the directive there makes that clear. It says, after the evidence leaders have presented the evidence of a witness, the public protector may cross-examine the witness. But look what it says when it comes to the evidence leaders. At 6.16, after members have posed questions, the evidence leaders may ask any question arising or seek clarity from the witness in relation to questions posed by witnesses, whereafter the chairperson shall excuse the witness. That's it. Once the witness is excused, there's nothing more you can do. So the evidence leaders have a right to do two things. One, pose questions arising or seek clarity, that's after the members, and sorry, I'll find the other, there's another reference that's missing here in paragraph 6. And that's the one where the evidence leaders also put questions. But anyway, I think everyone here now, by now, knows that.
Thank you. Thank you, Advocate.
There's nowhere in the.
Thank you,
No,
Advocate.
Chair, I'm left with.
I'm not asking for that. I'm now saying thank you, Advocate Mpofu.
Yeah.
I think it's good. You must listen to me as a chair.
Okay. No, I'm saying, Chair.
No, wait.
I know you want to have tea. I'm saying, can I just finish this?
Don't anticipate what I'm going to do.
Okay.
This is what is going to happen now. The time is 11:31.
31, yeah.
We're now going to take a break for 15 minutes. When we come back, the following will happen. Firstly, we would have started at 9:30, and as a chair, I would make the remarks until 9:37. I hand it over to Advocate Mpofu at 9:38 and use that time to place matters on record, including challenging the time. At 10, we had an audio problem. We resumed 6 minutes after 10. At 10:14, Advocate Mpofu started with the application, and I would have given him that hour. So at 10:15 or 14, that would have been the end of that hour. I added 15 minutes until 11:31. So I'm making that point to say we're taking a break now. That's a time I've given to Advocate Mpofu. I'm not giving any additional time. When we come back, I'm going to ask members to seek any clarities, if there are clarities that they need, and thereafter have a brief session of the committee to discuss as a committee. We take a break. Thank you.
Chairperson, before you take the break, I want to indicate that I'm not finished with my presentation or making my application, as I indicated. So whatever you do, henceforth, you must be on the understanding that I've not finished and I have some very important submissions still to make on this important application. And in fairness, you should allow it. If I were you, I would allow it at least to be finished, even if we know what the outcome is going to be.
Thank you, Advocate Mpofu. The point I'm going to make is that we have received your written submission, we have read it, given you an hour to make that. I'm giving no more time on your oral presentation. We take a break. Thank you. sharply as a matter placed on record by Advocate Mpofu. So I want to do the following. There's an issue that was raised that the response of the evidence leaders, and I've seen that members have received that. There seems to be a gap, and it's quite a serious one, that the public protector team has not received that response. And it's important that we close that gap so that their response is complete, or their presentation is complete. And so this is what I want to suggest, members, and I will hear from you. It's important that when you deliberate as members in our own time as a committee, you have everything. There's nothing missing out of that. And for that reason, I want to suggest the following. That the committee secretary had an oversight on this issue for not sending, at the same time that he was sending this to members, to send a response of the evidence leaders, which on its own is also quite a comprehensive response. The committee secretary is not here today, also has taken ill this morning, though just remained on the virtual platform. I'm not happy about that. I'm not happy with the fact that that important aspect was not ticked off. There's no other way to explain it. But we do need to have a remedy for it. And that remedy, therefore, colleagues, suggests the following. That the committee secretary will immediately send, you can argue that the documents that are sent to members are public document, but it has to be formally sent to the public protector. So immediately that must be sent to the public protector for them to peruse that. I would have indicated that Advocate Mpofu was also going to do the opening argument today. I think it's only fair that they are sent that they are given time to look into that, and therefore it would not be fair for us to continue as a committee to deliberate with that gap. And it suggests that there will be no need for us to proceed from now on, and do that, send that, they apply their minds, they respond to that. And I'm asking that the public protector team have this afternoon to do that, and overnight or early in the morning, 8 o'clock, submit their written response to what they would have received. And hence, I cannot take any more time from them for Advocate Mpofu to make leading arguments now that they are given that time to do that. And that will resume tomorrow. That would have, in the same way that you would have received the written submission of the evidence leaders, you'd receive that written submission and any other issues that they want to put into that, and that when the committee meets, has all of that to look into and deliberate on. So I'm putting that to you, honorable members, and let me hear what you think, both here and in the virtual platform. Honorable Mulder?
Chairperson, yes, I would support that. It was unfortunate that the public protector's team did not receive the reply. And I think the other members as well received the reply or the response by the evidence leaders late yesterday afternoon. It is comprehensive. I worked through that last night. And I think if, unfortunately, the Public Protector's team did have that, we may not have had necessary to listen to what we've heard this morning. But be that as it may, I suggest that what you propose is in order. Thank you.
Thank you, Honorable Mulder. Any other member? Honorable Maneli?
No, thanks, Honorable Chair. I also agree to giving time. But I also want you, Chair, to tighten up the other point. It was raised, I think, during the presentation time. And I think it's important to close also that gap. Because I think what was indicated was like there's been an issue even with the witnesses. Just to be sure that when we get back, those issues do not arise, at least everything else, it's in line, so that when we say we're proceeding, we proceed in a true sense. Thank you.
No, thank you, Honorable Maneli. As I promised Advocate Mpofu that we have noted that and will respond so that we, first thing tomorrow morning, will put that on record. And further work between now and then would have to be done. Any other members before I note you, Advocate Mpofu? Honorable Mautwe. Honorable Mautwe. Honorable Mautwe, your hand is up. Hopefully it's not a ghost hand. You are muted if you are speaking. That's fine. It's just a hand by mistake. Let's proceed. There being no other member wanting to comment, let me recognize Advocate Mpofu.
Yes, thank you, Chairperson. Just two quick things. One is, sorry, I didn't catch, Chair, whether the thing has been sent or you are saying it will be sent.
I want to make sure, so I'm saying it will be sent immediately.
Just in case, yeah.
I don't want to that there be an assumption that no, it was there this time, so that I need to be very sure about that.
Yes. No, thank you, Chair. Well, okay, then I just want to make two quick points. One is that, well, we can, I don't want to do that which I was accusing you of doing, Chair, of preempting something I have not seen yet. But the chances are that if it's as comprehensive as Honorable Mulder says it is, in content as well, then it will obviously be something that we may, and I can't put it higher than that, we may need to address again tomorrow, but we will indicate that tomorrow. I just don't want, I want when you are doing your planning, maybe to factor that in, that there's a possibility. I'm just making this in the dark because I have not seen the document yet. But we'll certainly endeavor to give you a written response. Yeah, we think the time is unreasonable again, but you know, as usual, we will try to comply with it, even if we think it's unreasonable. The other point, Chair, which I also just want, again, so that we don't have other procedural hiccups tomorrow, is that I have been informed that Advocate Ngalwana has submitted a complaint related to what we were discussing here to the Legal Practice Council. If I manage to get a copy thereof, we will post it in the usual way, and if it raises any new relevant issues, we will also deal with it in whatever period you might give us. The last point is that well, I've already made the last point, which is that in any event, even before that, and we appreciate the opportunity to have a look at the document, but even before that, we had not finished our presentation and do not appreciate the idea of being stopped in the middle of a sentence, literally. And but we were only left with one section, as you know from the document, which was the third ground. Yeah, I just wanted to say those things, Chair. Just hold on 1 second, please, Chair. Oh, thank you, Chair. I've also been asked to raise, for what it's worth, apropos the discussion we had about the 45 minutes, whatever. This is a point I've made here before, but it looks like I have to make it again. That this is not an oversight exercise, or when the public protector presents whatever she presents in Parliament. This is an inquiry that has its own life, so to speak, an ad hoc committee. And therefore, it is in that context that we were talking about issues of consistency within this. It may be that she gets given an hour or an hour and a half or whatever when she presents in Parliament. But if that time is not reasonable in relation to whatever is being done here, we want to make it clear. It's obvious that that point has always been missed here, that this is not, even with the type of evidence that gets led here, this is not an oversight committee of Parliament in the normal fashion, where you can ask anything you like. There are issues here which are confined to the actual charges that are being faced here. I'll just leave it at that, Chair. It's a matter that is of concern as to maybe going forward. Hopefully, we won't have to make that point again. Thank you.
Thank you. Thank you, Advocate Mpofu. Maybe just before I summarize and close, Honorable Gordhan and Honorable Mulder.
Thank you very much, Chairperson. Chairperson, I just wanted clarity on what's going to happen tomorrow, because we were supposed to hear from the first witness, being led by Advocate Mpofu. So I just wanted clarity on the impact of this now.
Yes, I will clarify that.
All right,
That's
thank you.
Thank you, Chair. I also forgot to say something.
Honorable Mulder.
It's on the same point, Chairperson. I wanted to ask that, seeing that the Public Protector's got a full legal team present, that I understand the first witness will be on his way today, that the time being used to prepare the witness so that we can proceed with that as well. Thank you.
Thank you, Honorable Mulder. Well, my understanding is that the witness would have been long prepared, but Advocate Mpofu.
No, your understanding is completely inaccurate. I don't even know where it is gained from here. But the issue, again, it goes to what we've been at pains to say here, I think from day one. There seems to be some, I don't know, zeal to just, go through the motions here and get it over with, chop the head and let's all go back to normal. It doesn't work like that. We need to be given fair opportunity to present our case. And that includes preparation time. That includes not what is happening here now, where we're told that there's some comprehensive document which we don't even know how comprehensive it is. And we must deal with it in writing tomorrow morning, prepare our responses to it, and prepare a witness. I mean, where have we ever had such a thing? It looks like even people who have a predetermined outcome must try to hold themselves back to pretend that there's fairness here. We're not robots. We're just going to be told by Honorable Mulder that the team is big or small or whatever. We know how our team operates, and we will tell you. I told you last week we were given the most unreasonable deadline on a Monday to say put the application in writing on Wednesday, knowing that we're the mammoth case in the Constitutional Court. We did that. We bent the midnight oil. We didn't sleep because we knew that if we don't do it, we're going to be told stories about, no, we want to stall this thing, or Stalingrad, and all sorts of things, all the insults that have been hurled at us. We did that. Now, raised a legitimate issue here. When we raised it, the chairperson should have immediately at that time said, no, let's stop there, right there, and let's make sure we give the opportunity. No, we're allowed to continue and continue with that handicap. And only after another 30 or 40 minutes, we're told that we're being given an opportunity. And now these members want to insist that we must do, I don't know what, miracle, and deal with that document and also prepare a witness. It's fine, we will try to do that because we've been abused enough when there's what more can be done now, what worse can be done. But we just want to record that when we're human too, and you know, no amount of eagerness to do any other predetermined outcome. That must be resisted as much as possible, and at least give a semblance that, you know, we're listening and we're not just waiting to hand down the guillotine. We know what is going to happen to all these things, but it's just unfair to treat us like this. You should treat us in the same way that you treated other witnesses, the evidence that was led before, where reasonable opportunities were given for people to prepare where they were not prepared, or to deal with unforeseen circumstances which inevitably arise in a process of this nature, which involves witnesses, outside people who are not, like all of us here, only committed to this process. It's just unfair, Chairperson.
Thank you.
Oh, yes. Sorry, Chair. I promise I'll be half a second. Yes, just to confirm what the Chair was saying, our latest information is that the witness will arrive sometime in the early evening. He says he doesn't know where he's going to be booked to stay, but hopefully by that we'll try and interact with Tembingosi so that we can locate him and prepare him. Thank you.
Thank you, Advocate Mpofu. I did see your hand. I'm sure you can allow me to do the summary without interacting again back. Colleagues, this is what is going to happen. We will adjourn now, okay? Which is an early adjournment, which allows for yourself as members to do other work and everybody else to do other things with the afternoon that was not budgeted for and planned. It's that Christmas time that you're getting, Christmas afternoon, to be able to catch up on other things. We will start tomorrow at 9:30 as indicated in the program, and we'll start with the committee deliberations. Having received the submission of the public, the written submission of the public protector, after that committee deliberations and with its outcome, either way being presented thereafter, we're going to allow the public protector team to make the leading arguments. The plan is for us tomorrow afternoon to have the witness on the stand, to start with the witness. I take note. I see you. Before I conclude, you don't want me to conclude. You want to say something before I conclude.
Sorry, Chair. Yes, please, if possible.
Okay, let me give you that so that I conclude properly.
Yes. No, Chair. No, I just want to make 2 quick points. I just received instructions to make a request to you that, seeing that we are adjourning, and we may not even have. Well, we certainly don't have the witness here, and we may or may not even have the document, which I'm sure will be with us in a short space of time. That you allow us to conclude our presentation, because otherwise it will just be wasted time, so that at least that part is done. If there's any other request to say anything, it should be only in relation to the stuff we don't have, not the stuff that we do have. So that's the first issue request, Chair. Just to round off the points, as I say, where we were stopped mid-sentence, just to finish that off so that we can make value of today's expenditure on the inquiry. The second one is this issue that you've just addressed, and I'm not going to repeat the issues that I've said about how unfair it is in terms of duration of time. That goes without saying. But Chairperson, I want to register here that your remarks and the remarks of the members who are saying that the witness must come in tomorrow at such and such a time and so on is the clearest indication that you have already decided this matter. How do you know what will be the outcome of the application? Because at least, that's why I'm saying at least people must pretend not to have made up their minds. Because once we start talking about the witness is going to do this or that, then it means that we already know, we do know what the outcome is of the application will be. But let's pretend for the sake of the public that we don't know, all right? So that we at least say, well, if the application goes this way, this is what will happen. If it goes this way, this is what will happen. We can't. I mean, it's a joke to waste the taxpayers' money on something this important and then just pretend that as if the public protector has said nothing when she has made very serious submissions here. People, as I say, they must just try to not to display to the public. Let's at least think about the public that is watching this and not...
Thank you, Advocate Mpofu.
You know,
Thank you.
Sorry.
Advocate
Yes, Chair,
Mpofu,
I hear you.
I want you to conclude, please.
Yes, no, well, okay. On a positive note, the note that, oh, no, it's not positive as I thought. Advocate, please note that no return travel confirmation received yet and still waiting for transport. It's now 12:02. That's from the witness who was told that he was going to be picked up at 12.
Thank you.
I've made the earlier point.
Thank you. Here it is, colleagues. Let me conclude my summary and the way forward. Let me start with the point you've raised, continue to raise. We've received your written submissions. We've allowed you to give oral presentation and gave you time and extra time. It is done. I'm not giving any other time on that. We have that and on record, and we've gone through it. In relation to...
Well, Chair, the members of the public might want to know what we have to say. If you are not interested...
Thank you, don't disrupt me, Advocate Mpofu. So that is
no, I
done.
just wanted to record, Chair, that you are being so unfair. Why would you want to stop us when there's nothing...
Advocate Mpofu, please
there's nothing that's going to be done
switch off
now.
your mic,
Why can't you
Advocate
give us 20 minutes to
Thank
finish
you, switch
our
off your mic,
presentation?
Advocate Mpofu. Because we work according to time in everything we do.
Time for what?
Please
The
switch
time
off your
was
mic,
supposed to
Advocate
be
Mpofu. I'm on the chair.
No, but Chair,
No, but I'm on the chair. I
registering
did
a
not disturb
protest.
you when you are speaking. Please switch off that mic.
Don't shout at me.
Please switch off that mic, Advocate
I'm
Mpofu.
not going to switch it off if you're shouting at me.
Please switch off that mic, Advocate
No,
Mpofu.
I'm
I'm
saying-
speaking now, and you can't continue disrupting me.
No, I'm not disrupting you,
Then
Chairperson.
stop.
Okay.
I'm going to conclude.
Then
what I'm doing.
recognize me then.
I'm not recognizing. Let me conclude.
Thank you.
Here, what is going to happen, colleagues. There is no extra time that is going to begin for your oral reply. The fact that you did not finish it, having given time, can't be the problem of this committee and myself as a chair. Because everything we do in every institution, in church, there's a time given. The church starts at this time, finishes at that time. Everywhere else, even kindergarten, they're given time to play for this moment and collect their toys and do this. Every institution has that. We've got rules here of the National Assembly. We've got directives. And the chair always must be able to direct those, including issues of time. So I'm not going back to that issue. And I've explained to you what the standard is. Second point that I want to... so I do continue to say that we're going to start tomorrow in the manner that I've indicated, 9:30, with committee deliberations, having received all of the written submissions, and we would allow Advocate Mpofu there. When we come back from that committee, we'll then indicate what the decision is, either way. And I've made that point. And we'll allow him to make these leading arguments. And we're going, between now and end of the day, everything is going to be done for the witness to be on board. In fact, out of the 16 witnesses we had in the first part of this, there could only be about 3 or 4 that were here physically.
It's 4.
Nothing stops us continuing with a witness virtually. And I want to make that point, okay? So they were there. You had Ibrahim there, you had Samuel there, and you would have No, and the other one that I can't remember. It's just 4
Mahlangu.
out of the 16. And it doesn't mean that there's been no inquiry. So with that, colleagues, I think the time now is 12:15. I am asking that the public procurator team with agenda in order to give them time to go and look at the submission of the evidence leaders, do that written submissions. We come back tomorrow, we continue with our meeting. I thank you, members. The meeting is
Person, you
adjourned.
said you were going to
I said I was
me.
not going to recognize you. The
You
meeting
said
is
you're
adjourned.
not going to recognize
The
me.
meeting is adjourned. Thank you.
Hey, Banna. Hey, Mr. Chanchi. It is a dictatorship. Carry on.